Salutations. Greetings, guys. Sanbonani. How are you guys? I'm well. I'm doing great, guys. I'm doing great. I hope you guys are doing well as well, guys. Okay, guys. Today we're going to be doing chapter 7 of the basic conditions of employment, which is a very key matter of variation of basic conditions of employment. This is a very important one because I think in most cases, this is what also the complaints that we get about, whereby the employer just varies the conditions of employment without the employee knowing, without any due process, without any consultation. So this is very important one, guys. And I still urge you guys, please subscribe to the channel, please invite others, please share this video, the videos, please share it on different media platforms that we are using to ensure that we grow this platform, and this information and reaches as much people as possible to ensure people are empowered, because it's about empowerment, it's about education. This is what I'm trying to do here, guys. So okay, guys, let's get to it. The chapter 7 of the basic conditions of employment, guys. Variation of basic conditions of employment. Variation by agreement. Number 1, a collective agreement concluded in a bargaining council may alter, replace, or exclude any basic condition of employment if the collective agreement is consistent, keyword consistent, with the purpose of this act, and the collective agreement does not a. reduce the protections afforded to employees by section 7 and 9 and any regulation made in terms of section 13. B. Does not reduce the protection afforded to employees who perform night work in terms of section 17 subsection 3 and 4. Does not C. reduce an employee's annual leave in terms of section 20 to less than 2 weeks. D. Does not reduce an employee's entitlement to maternity leave in terms of section 25. E. Does not reduce an employee's entitlement to sick leave in terms of section 22 to 24. F. Does not conflict with the provisions of chapter 6. 2. A collective agreement other than an agreement contemplated in subsection 1 may replace or exclude a basic condition of employment to the extent permitted by this act or sectoral determination. 3. An employer and an employee may agree to replace or exclude a basic condition of employment to the extent permitted by this act or a sectoral determination. 4. No provisions of this act or sectoral determination may be interpreted as permitting a contract of employment or agreement between an employer and employee contrary to the provisions of a collective agreement. B. A collective agreement contrary to the provisions of a collective agreement concluded in a bargaining council. 50. Variation by minister. 1. The minister may, if it is consistent with the purpose of the act, make a determination to replace or exclude any basic condition of employment provided for this act in respect of A. Any category of employees or categories of employees, or B. An employer or employee in respect of whom an application is made by 1. The employer, 2. The registered employees organization, 3. The employer and the registered employers organization. 2. A determination in terms of subsection 1 A may not be made in respect of section 7, 17, subsection 3 and subsection 4, 25, 43, subsection 2, 44 or 48, or a regulation made in terms of section 13. And B. May only be made in respect of section 43, subsection 1, to allow the employment of children in the performance of advertising, sports, artistic, or cultural activities. 2A. A determination in terms of subsection 1 may only be made in respect of section 9 if A. The employee's ordinary hours of work, rest periods, and annual leave are on the whole more favorable to the employees than the basic conditions of employment in terms of section 9, 10, 14, 15, and 20. And B. The determination has been agreed in a collective agreement. 2. It is necessitated by the operational circumstances of the sector in respect of which the variation is sought, and the majority of employees in the sector are not members of a registered trade union. Or 3. Applies to the agricultural sector or the private security sector. 3. A determination in terms of subsection 1A must A. be made on the advice of the Commission, and B. be issued by notice in the Gazette. Number 4. The Minister may request the Commission A. to advise on any application made in terms of subsection 1B. B. to prepare a guidelines for the consideration of applications made in terms of subsection 1B. Number 5. A determination in terms of subsection 1 that applies to the public service must be made by the Minister with the concurrence of the Minister for the Public Service and Administration. 6. If a determination in terms of subsection 1 concerns the employment of children, the Minister must consult with the Minister for Welfare and Population Development before making the determination. 7. A determination in terms of subsection 1B may be issued if the application has the consent of every registered trade union that represent the employees in respect of whom the determination is to apply. B. If no consent contemplated in paragraph A is obtained, a determination in terms of subsection 1B may be issued if 1. The employer or employer's organization has served a copy of the application together with a notice stating that representations may be made to the Minister or any registered trade union that represents employees affected by the application. And 2. In the case where the majority of employees are not represented by a registered trade union, the employer or employer's organization has taken reasonable steps to bring the application and the fact that the representations may be made to the Minister to the attention of those employees. Right? Still following, guys. 8. A determination made in terms of subsection 1B A may be issued on any conditions and for the period determined by the Minister. B may take effect on a date earlier than the date on which determination is given, but not earlier than the date on which application was made. C must be issued in a notice in the prescribed form if the determination is made in respect of an application made by an employer. All right, still following, guys. D must be published in a notice in a gazette if the determination is made in respect of an application made by an employer's organization. Number 9. The Minister may, on application by any affected party and after allowing other affected parties a reasonable opportunity to make representation, amend or withdraw a determination issued in terms of subsection 1. B. For the purpose of paragraph A, an affected party is 1. An employer or employer's organization that is covered by the determination. 2. A registered trade union representing employees covered by the determination. 3. Or an employee covered by the determination who is not a member of a registered trade union. Number 10. An employer in respect of whom the determination has been made or whose employees are covered by a determination in terms of subsection 1 must A. display a copy of the notice conspicuously at the workplace where it can be read by the employees to whom the determination applies. B. Notify each employee in writing of the fact of the determination and of where a copy of the notice has been displayed. And C. Give a copy of the notice to every registered trade union representing those employees, 2 trade union representatives representing the employees, and 3 employee who requests a copy. All right, guys, that's the end of this chapter. Then in the following video, we'll then deal with chapter 8. That was the end of chapter 7, guys. Thank you very much, guys, for tuning in. Please continue supporting the channel. Please subscribe. Those who have not subscribed, please subscribe. Those who have subscribed, thank you very much, guys. Please continue watching the videos. Please share on the different platforms so we can spread the message. Thank you very much, guys. Lsidi, Khanya, Makhanya.